Hello, everyone. I am Jeff Smith. I'm a shareholder here at Altitude Community Law. Today, we're going to be learning about the Colorado Civil Rights Division and some discrimination issues. On your screen, you will see the PowerPoint presentation in the center of your screen. This should take up most of the screen. There should also be a small box on the bottom right-hand side of the screen with a video feed. That will have my face on it. On the left side of the menu, please select the question and answers icon and type all your questions there. I will do my best to answer them at the end of the webinar, but this is only an hour-long webinar and there's a ton of information, so I will do my best. If not, you can always email me at jsmith@altitude.law, and I'll answer your questions from there. CMCA credits are automatically generated once the webinar hosting site provides an attendance confirmation report and will be sent via email within 48 hours following the webinar. These credits are not transferable. Please email education@altitude.law or call Sean directly at 303-991-2076 if you have any questions about receiving your CMCA certificates. All right, let's dive into this quickly. All right, so there are multiple different types of enforcement bodies that deal with discrimination. You have HUD, which is the United States Department of Housing and Urban Development. Their mission is to ensure the access of every American to a decent, safe, and sanitary home and suitable living environment. Then we have Colorado-specific areas like the Colorado Civil Rights Commission and the Colorado Civil Rights Division, commonly referred to as the CCRC and the CCRD. The CCRD is the enforcement arm of the CCRC. HUD has certified that the CCRD has a substantially equivalent agency. So basically, complaint comes into either HUD or the CCRC, and it's the CCRD who will be enforcing the matter. Every so often, HUD will do it, but that's pretty uncommon. So who is the CCRD? CCRD is a government agency that enforces Colorado's anti-discrimination law. They work hand in hand with the EEOC, which is the Equal Employment Opportunity Commission, and the Housing and Urban Development, HUD. Their job is to investigate claims of alleged discrimination. The CCRD conducts hearings on character, causes, and extent of illegal discriminatory practices throughout Colorado. They also advise Governor and General Assembly on policies and legislation, review appeals of cases investigated and dismissed by the division, and adopt and amend rules and regulations in the enforcement of the state's discrimination statutes. So charges. When a homeowner goes to the CCRD and says that they're being discriminated against, the CCRD will file what's called a charge. These are housing complaints. They must be filed within 1 year from the date of the last occurrence of the discriminatory act, or the CCRD will not investigate the claim. CCRD drafts the charge and serves on respondent. So one of the reasons you see owners going to the CCRD instead of filing their own lawsuit is that the CCRD will do this for free. So all the owner has to do is they submit their complaint, and then the CCRD will investigate it. That's one of the big benefits to homeowners and why we see so many of these CCRD complaints every year. Typically, in my office, we're going to see probably 15 to 20 CCRD complaints every year against associations. And so it is commonplace. And so that's why we're teaching this class to hopefully try and stop some of those pitfalls and avoid the association, the expense of having to respond to these charges. So once the CCRD drafts the charges and serves on the respondent, which would be the association, and oftentimes they'll name the management company, they might name individual board members, they try to name as many people as possible. But those would be the respondents. So the respondents are then given a chance to respond and provide information. We're going to dispute the resolution, typically. Very rarely would we say, yes, let's just admit that it took place. There will be an investigation. So more recently, the CCRD has been doing follow-up interviews. So we would submit our response, and then the investigator has been reaching out to both the complainant and the respondent for interviews. We'd want you to have your attorney there with you for it. And the interviews usually last about 30 minutes, and they're just trying to clear up some questions they might have between the response and the answer. The division director will then make a determination, and that will become in writing. If they find probable cause, then conciliation will happen, which is basically a forced mediation. And when you go to conciliation, the association doesn't have, it's not like a typical mediation where there's a neutral party there. Typically, it's going to be geared towards the complainant. And so typically the association is going to be required to take some sort of steps to remedy the situation. If there's no probable cause, the owner has the ability to appeal that decision to the Colorado Civil Rights Commission, and then the CCRC can make a determination as well. Additionally, the owner can file a federal lawsuit if they don't like what the CCRD has done. However, it's pretty rare that a no probable cause challenge finding would lead to any type of federal charges. It typically, if they couldn't get the response they wanted for free, they don't want to go spend money trying to get that same response. So one thing to keep in mind is a very quick turnaround when you get these CCRD complaints charges. You need to get them to your attorney as quick as possible. There's a lot of documents that we'll go over that are needed so we can get the response done quickly. It used to be that we could reach out to the investigator and they'd give us 3 weeks, maybe a month to prepare these responses. Now they are wanting them basically within 10 to 14 days. So it is a very quick turnaround. So make sure as soon as this comes in that you get it over to your attorney's office. So the request for information, which is part of our response, or our response, I guess, is part of the request for information. Things that we're going to need to be turned over to them are the governing documents. So any policies, rules and regulations, obviously the declaration, bylaws, anything along those lines. Any resolutions that are prevalent to the discrimination claim. Any correspondence with the homeowner. Any meeting minutes that might be relevant. Typically, there's going to be some type of violation issue that's leading to this discrimination claim. So we're going to want all the violation logs. We're going to need a homeowner list, a list of any prior accommodation requests that have been sent, or any discrimination claims that have been filed against the association in the past. We're also going to be looking for photos. And then once we have drafted our response, the board or manager, depending on who's all been named in this, we're going to seek affidavits attesting to the information that we have put in the response. So all of this requires a lot of communication between your attorney and the management company, or if it's a self-managed board, the board itself. And once these come in, it's pretty much a fire drill until that 14 days is done, because we have such a short amount of time to get these responses in. Once we get the response in, then it's kind of a waiting game. Typically, they have 180 days from when they filed the complaint to reach a decision. Oftentimes, they will request an additional 90 days from the parties. So it can be up to 270 days before we actually get a determination. Excuse me. So following the review. So after the CCRD receives information, it can request additional information if that's necessary, or what's more likely to happen nowadays is they're going to request an interview with whoever has the most knowledge on this situation. CCRD will then issue a probable cause, either probable cause found or no probable cause found to believe there was a violation. So if probable cause is found, the case will proceed to conciliation, and then a case may be filed with the AG office if we can't reach a resolution during conciliation. If no probable cause is found, the complainant may still appeal to the CCRC or file the matter in state or federal court. Sorry, there's a typo there. That should be CCRC, not CCRD. And so again, the typical process is the complainant files the complaint is filed by the charging party. The CCRD then goes through the steps of actually making the complaint and sending it to the association. The charging party then responds. The investigator will then do its investigation. If no probable cause is found, more than likely the issue is done. It's very rare that they appeal the decision. It's also very rare that they end up filing a federal lawsuit. If probable cause is found, then the association would have to go to conciliation. And again, that's a mediation that we would try and resolve that issue at any chance we can get. Typically, we're going to have to fall on the sword and basically do whatever the CCRD wants us to resolve the matter. In addition to that, if we don't get the conciliation, then it would go to the AG's office, and the AG has the ability to issue actual damages of $10,000 to $50,000 if they find a violation has taken place. This is a much smaller amount than what happens if they move forward with a federal case. In a federal case, you're typically talking hundreds of thousands of dollars in terms of damages, sometimes upwards to $1 million. Even after this process is all done, the owner could still go forward and file a federal claim if that is what they so choose. So these cases can cause associations lots of money. And again, that's why you got to get it to your attorney as quick as possible. Now, Apologize, I am trying to go fast because there are a ton of slides and a ton of information. All right, how can we try and prevent these claims from being filed against the association? First thing is, like we say with everything in terms of covenant enforcement, be consistent in application of policies. So make sure, one, that you have policies in place and that you're following them. We would recommend also that you have a reasonable accommodation policy in place. That helps the association make sure that they're being consistent with all owners. Again, as managers, make sure you're documenting and writing all communications and decisions. Be sensitive to requests made by members of a protected class. And we'll go over who those protected classes are here shortly. Make sure you're educated as to fair housing requirements. And since you're attending this class, that is a good first step. One of the things that the CCRD wants to see is dialogue. So if some owner comes and they're requesting an accommodation, they want to see the association engage in dialogue and try and resolve the issue. So if we say no, that no, you can't have this, they're looking for the association to offer alternatives. One issue that can come up is explaining what is needed or seen as deficient cross into giving legal advice. So what we don't want to do is be giving the owner any type of legal advice. If they are requesting an accommodation maybe for an emotional support animal, and the association for whatever reason believes it has grounds not to, we want to make sure that we're trying to give other opportunities or other options as to what might be allowed. And maybe it's more of a reasonable modification where they want to put in handrails in this location. And while we won't allow them in this location, we might allow them somewhere else that would help this individual. So that's what the CCRD is looking for, to make sure that the housing authority is doing as much work with the owner as possible to try and resolve the issue so that everyone can live in the property as they should be able to. So some more prevention things. Have legal counsel review your governing documents for any discriminatory language and revise appropriately. Typically, where we're going to find discriminatory language is in your rules and regulations. Oftentimes, if there's a pool involved and there's adult swim only, that might be a discriminatory policy. If there are rules that say no ball playing or something, no using toys on common elements, that would be something that could be discriminatory, as it's only pointing out people by their familial status and age. So these are all things that we would be able to look at. Again, you want to adopt a policy for all requests, so all reasonable accommodation requests. We would definitely advise that all associations have that. You want to make sure you're taking a cooperative versus a defensive stance with the requests. Make sure you're keeping good records of all covenant violations, rule enforcement actions, and requests for architectural approval, because we're going to need all those documents to show to the CCRD that we're not being discriminatory. We are treating everyone in the same manner. And just because we denied their request does not mean that this was some type of discriminatory action. So in terms of having that policy, when a request comes in, requesting a reasonable accommodation, we want to make sure we get a response to them within 30 days of the request. It has been found by courts that if you delay, that is the same as denying. And so that's why we want to make sure things are done within this 30-day time frame. That may require your board to have a special meeting or take action outside of a meeting. If that's what needs to be done, that needs to be done. And that's why you need to get these, when you're dealing with any kind of discrimination type claim from an owner or a reasonable accommodation request, you need to get those to your attorney as quick as possible so that they can weigh in and let the board know what their options are. We also want to identify the limited scope of what may be requested. So a person might be disabled. Maybe they have a hearing issue or something along those lines. And the request that they're wanting is to put in a handrail. Well, the hearing issue has nothing to do with a handrail. And so, again, that wouldn't necessarily coincide. So we wouldn't have to grant that accommodation or modification. So we want to make sure whatever the disability is related to what the reasonable accommodation is. Again, all requests should be reviewed by counsel. And this is an expense that cannot be passed to the owner or applicant. That's something that's going to be borne by the association. If you do charge those attorney's fees back to the owner, in this case, the CCRD has said that that's retaliation, and that will lead to another CCRD complaint. Other things to keep in consideration. So the applicant for a request is not required to be the owner or the person in need of the accommodation or modification. So it doesn't have to be an owner. It could be a tenant. It might be someone that is a relative of the owner and they are going to be over there often, and that's why the accommodation needs to be made or modification. So keep in mind, it does not need to be the owner of the property who's making this request. Secondly, don't request any medical information if the disability is obvious and it's obvious how the requested modification will contribute to the use and enjoyment. So if an individual puts in a request saying they need a wheelchair ramp and they are in a wheelchair, we don't need any additional medical information on that because it's obvious why they need the request and that they are in a wheelchair. Also bear in mind that when we're requesting information that the healthcare provider is not required to be a physician. So it doesn't have to be a doctor per se who is sending in the information telling us that an individual is disabled. Again, we want to make sure we're responding to requests in writing and in a timely manner. If there is no request for an accommodation, there generally is no obligation to make the accommodation. So just because we see someone in a wheelchair doesn't mean we need to go up to them and ask them, do you need some type of accommodation? However, what constitutes a request can be a dispute. There's no magic language that they have to put in any type of request. So if they do it verbally, make sure we're following through. If they put in a writing that they don't say I need a reasonable accommodation or reasonable modification, but they say I would like to put in a wheelchair ramp, we need to treat that like a reasonable accommodation request. Do not deny a request because of a related or unrelated violation at the time of the request. Place any violations on hold while the applicant obtains while we get the requested information from them. So if it is someone who's requested an ESA and we've sent them violations for that dog, we don't want to continue with those violations. We want to put those on hold until we've evaluated whether or not they are entitled to have the ESA or not. And then applicants will generally not be liable for the cost of an approved accommodation. There's typically not a whole lot of costs in an accommodation, and a modification that can change. So if there are physical things that need to be done, that is something that we can pass back to the owner or have the owner pay for themselves. But in terms of an accommodation, that's typically just a change of rule. The only one that is sometime a dispute between is an accommodation or a modification is a curb cutout. There's case law that says that that's an accommodation and not a modification. And so with that curb cutout, it would be the association's responsibility to pay for that, not the owner. All right, if you're going to deny someone a reasonable accommodation, one, again, make sure you've talked to the attorney and they are agreeing with this decision. If you are going to deny, we need to make sure that we're documented thoroughly as to why we have denied the request. You need to remember that the law allows disabled persons to enjoy their homes to the same extent as those without disabilities. So if what we are doing is not going to allow the owner to enjoy their property the same way that an able-bodied person would, that is problematic. And also remind your boards to be reasonable. Again, even if we win and we fight this and we win, you're still going to lose because you're going to be out all the attorney's fees and this individual still lives there. And so you're going to have to be living with them going forward. So we always want the boards to be as reasonable as possible. Educating managers, like we're doing right now, is one of the key things. So you guys are aware of what the laws are, what you can and can't do, and when you need to get it to the attorney's office. We would recommend that the boards have us review governing documents to make sure, especially rules and regulations, to make sure that they are in compliance and not discriminatory. Obviously, good record keeping, and then make sure that you have that reasonable accommodation and modification policy. It's very helpful to the association. It just streamlines things and it makes it much easier for the board to make a uniform decision each and every time. So some of the consequences, if we lose at the CCRD or if we lose at a federal level, it's a high cost. It can be anywhere from $1 to $1 million. Settlements are extremely high. We had a case up in the mountains regarding a emotional support animal. The animal they threatened to fine the dog, the tenant who had this dog. The tenant then moved out, and then both the tenant and the owner sued the association for discrimination, and both of those parties were paid out in excess of $500,000 to each one. So over $1 million was paid out, and the dog was never even, no fine was actually issued, and the dog didn't have to leave. It was simply because we threatened to fine. So they can be extremely expensive. You need to make sure you get them to the attorney as quickly as possible. Again, even if you win, you still lose. You're paying for the cost of hiring legal counsel. There's time and aggravation for the board, and it can be a public relations nightmare. No one wants to be in the newspaper for denying someone a reasonable accommodation for a disabled individual. And again, remember that you can't charge back the cost of hiring legal counsel. It's not your typical HOA matter where we get to charge those fees back. In this case, we cannot do that. All right, so now we're going to kind of switch over to some of the definitions regarding discrimination so that we can help you hopefully stay out of any kind of pitfalls. So the CCRD and the ADA and the FHA, which is the one that we're typically dealing with, the FHA, applies to housing providers. So who is a housing provider? Again, housing provider is someone who's in the sale, rental, use of a dwelling. So that's what it's pertaining to. By whom? Homeowners associations, managers, real estate brokers, contractors, lenders, real estate salespersons, appraisals, landlords. All of those are covered housing providers. So the association and the managers are deemed to be housing providers. So you are subject to the FHA and you are subject to CCRD complaints. So takeaway. Both an owners association and a management company qualify as housing provider according to HUD and the CCRD. Federal statute. So Title 8 of the Civil Rights Act and the Fair Housing Amendments Act, which you commonly hear us refer to as the FHA, it describes disability basically having the same meaning as a handicap. It is more commonly used and accepted. So it's typically any handicap, mental, physical. There are familial status. There's a bunch of different classes that can fall under the FHA for discrimination. And when we're talking about disability, oftentimes we think about someone in a wheelchair, but it can be, if you have allergies that are severe enough, that can be a disability. There are lots of, if you have mental issues, that can be a disability. There are lots of things that qualify as a disability. So you have to be aware of that. It's not you have to broaden your understanding of what a disability is. So the Colorado Civil Rights Act, again, relates to housing practices, allows for actual damages to be awarded. That's the $10,000 to $50,000. Allows for penalties to be imposed, which aren't insurable. Court orders requiring compliance, so it can be very broad, and an award of attorney's fees to that individual if they have to go through it. So if they win, they can be awarded their attorney's fees. We would not be awarded our attorney's fees. So some fair housing protections. So different types of classes of people that are going to be protected, or things that you can't discriminate against. So you can't discriminate based on race. You can't discriminate based on creed. That's not a federal one, that's a state one. Color, religion, sex, gender identity, orientation, disability, familial status, marital status, national origin, ancestry, and sexual harassment. The ones that are bolded in black, so religion, disability, and familial status, those are the ones that are most common in HOA realms. Those are the ones that we see a lot. Typically, the two ones, biggest one, are the disability and familial status. Those are the ones that we see popping up all the time. So things to be aware of. So different types of discrimination. Discriminatory treatment. This is provision that discriminates on its face. So this would be something saying that no children allowed in this area, this common area. That would be on its face discriminatory because you're prohibiting a class of people from using space that everyone else would be able to use. Then there's something that's disparate impact. That's facially neutral, but is discriminatory just by the virtue of what it's doing. So in that kind of way, it might be something that says pool rules, you can't have anyone. So with a disparate impact, we're talking about, say it's pool rule, we are saying only people that are 25 and older. That's not a good word. I'm trying to give you a good idea for a facially neutral one. We don't see these ones as often. So maybe an easy one, so occupancy. So if your declaration has something that says you can only have no more than 4 non-related individuals in a home, that is probably facially neutral, but the impact of that is discriminatory because you would allow a family of 6 or 8 to be there, but you're not going to allow 4 unrelated individuals to live there. And so on its face, it doesn't appear to be discriminatory, but when the actual intent of it is to prohibit, limit the amount of people that are not family related. So that can be discriminatory. Other things that come up, types of discrimination. So refusal to accommodate a protected person, refusal to allow modification for a protected person. Those ones you guys run into probably fairly often. So when HOA inactions can trigger scrutiny. So when an HOA has a covenant or rule which prevents a homeowner from using and enjoying their home because of one of the listed protected areas, and the HOA refuses to make a reasonable accommodation or modification. Another time is when the association fails to fairly and consistently apply its governing documents to all. So selective enforcement can be a discrimination tool in terms of if we're only enforcing against people of a certain race or people of a certain creed or based on their sexual orientation. If we are only enforcing rules against those individuals, that's obviously going to be discrimination. Likewise, if we have rules that when applied to someone who is not disabled or is not a protected class, and someone in that protected class brings up ask for an accommodation or modification, we don't grant it, that can be discrimination. So let's talk a little bit about familial status. This is discrimination based on families with children. Again, when this usually happens is in rules which will target families or children only. So such rules might be adult-only swim time. It's much better and proper to have a lap swim time, not an adults-only swim time. Because if a child, whether they're 7 years old or a person is 60, if they are swimming laps, that shouldn't be an issue. It shouldn't matter how old they are. It should just simply matter that the purpose of that time frame is for people to swim laps so that adults can enjoy the pool, so that individuals can enjoy the pool in the same way and not just in an open swim. Another thing that you might see that could be discriminatory towards families is no playing ball or skateboarding in this area. We've been challenged on that recently as to whether or not something like a no skateboarding or riding bikes is discriminatory. There are some associations that would be exempt from the familial status. Those are HOPA communities, so those are Housing for Older Persons Act. If they are qualified under that, then this discrimination based on age or familial status isn't going to apply. Okay. So, reasonable accommodation. In housing, it's illegal discrimination to refuse to make reasonable accommodations in rules, policies, practices, or services when such accommodations may be necessary to afford such person equal opportunity to use and enjoy a dwelling. So again, an accommodation is going to be a change to a rule to allow someone who's in one of the protected classes to be able to use the property in the same way that anyone else would. And if you fail to grant that reasonable accommodation, you can be found guilty of discrimination. So again, things that are important here. It's illegal discrimination to refuse to make the reasonable accommodations. So again, it needs to be reasonable and it needs to be necessary. So those are the two kind of key words that you want to focus in on. Is the accommodation reasonable, and is it necessary for this individual to be able to enjoy the unit in the same way that everyone else would? So we must make a reasonable accommodations to allow full use and enjoyment of the premises. It's deemed reasonable if it does not result in undue financial and administrative burden, fundamentally alter the nature of the housing in question. So reasonable is pretty broad in terms of the CCRD and HUD. Undue financial and administrative burden typically does not come up with an accommodation. The fundamentally altering the nature, that might. Sometimes we just recently had a request in where it's a individual in a wheelchair. They are responsible for taking out their garbage in a townhome every day. They are asking if they can get an accommodation that someone from the association come and pull their trash in and take it out once a week when the trash comes. That would alter the nature of the housing in question. That's not something that associations typically do. We don't bring in and out trash for homeowners. So that's something that would fundamentally alter the nature of what it is we do. So we could reasonably deny that, which is different than something where it's a dog-free community. This individual needs an emotional support animal. By allowing the dog, that doesn't change anything in the actual nature of what we are doing. It's simply a accommodation to a rule that allows the dog so that the owner can live in that unit the same way that anyone else would want to. Sometimes you will get competing disabilities. There's very limited case law on that. So sometimes you'll have in a dog-only community, a individual requests to have an emotional support animal, and someone next door maybe is allergic to dogs. And so you have two competing disabilities, and who trumps? Typically, who trumps is the first in time, or at least that's what the case law has said so far. And they're going to look at the severity of what is going on. So who it benefits more. Those are extremely difficult. And again, obviously with any kind of request regarding disability, you need to get it to the attorney, but those ones especially are going to be difficult, and be prepared to spend some money on trying to figure out what the proper rule is. Okay, so talking about animals. So reasonable accommodations when there are limitations on animals in the community. You can, if you have rules or declaration that prohibit size or breed, they cannot be imposed. There's very limited ability to restrict the type of animals. So if you have a no pit bull rule, or no dogs over 50 pounds, and the ESA or service animal happens to be a pit bull or a dog over 50 pounds, these rules are not going to be able to be applicable. You're going to have to give an accommodation to those rules to allow for that support animal to be there. Likewise, if it's an emotional support animal, it does not need to be a dog. Emotional support animals can be all sorts of things. We've seen turtles, we've seen geese, we've seen ducks, pigs. There are all sorts of things that have been deemed to be emotional support animals. Now, typically, if we probably would have a better chance if this is some type of a farm animal and we are in a condominium. Now, if we're in a single family house, then the likelihood of us being able to restrict the type of animal is pretty small. So again, another thing to remember, in terms of a service animal, which we'll talk about briefly, service animals need to be dogs or miniature ponies. Outside of that, it can't be other animals. So now, one exception to any of these kinds of emotional support animals is if the animal is dangerous. So if it has actually attacked someone, then we have the ability to remove that animal or not allow it. And we'll talk about that in a slide here in a second. Additionally, the expectations of the community of not having this type of animal typically is not something that's going to trump an individual's right to a reasonable accommodation. All right, so let's talk about disability briefly. A physical or mental impairment which substantially limits one or more major life activities. This can be shown by a record of having such an impairment or being regarded as having such an impairment. So if you were to look at someone and it appears to you that they have some type of physical disability, the likelihood is that it's going to fall under a physical disability, simply because that's what they're being regarded as having such an impairment. So being regarded as having a disability, when a covered entity mistakenly believes that a person has a physical impairment that substantially limits one or more major life activities, or a covered entity mistakenly believes that an actual non-limiting impairment substantially limits one or more major life activities. So if we are discriminating against someone because we think they are disabled, it's pretty rare. Typically you see this more in an employment setting than in a housing setting, but that is something that can still be discrimination even if the individual is not disabled. All right, so let's go over some definitions of service animals, emotional support animals, and then the overall reaching assistance animal. So a service animal means any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical, sensory, psychiatric, intellectual, or other mental disability. So again, key things for a service animal. It has to be a dog or a miniature pony, and they have to be trained to do a specific task. That is different than emotional support animals, which we'll get to here in a second. And most things that you guys are going to see are emotional support animals. When it's someone who's requesting an accommodation and they have a service animal, an actual service animal, they typically know the rules, they know all of their rights, and they know exactly what they have to provide to you. Oftentimes, it'll actually be an emotional support animal, and someone will claim it's a service animal because they don't understand exactly what it is they have. Again, there's the trained miniature horse. So assistance animals, or ESAs. If the animal is not a dog, but is a type typically kept in homes and other criteria met, the application should be granted. This is coming, so in 2020, HUD put out guidelines, and so it's something that you can Google, the 2020 guidelines that deal specifically with emotional support animals. I would highly advise you guys looking at it. It's a great resource, but ultimately, if it's a animal that is normally kept in a home, and they have the proper documentation from a doctor saying they need an ESA, that type of application should be granted. So dealing with unique animals. Unique animals may be required for approval under select and specific circumstances. So perhaps the owner is allergic to dogs and they need a different animal that doesn't have that allergy. That might be a reason why we'd have to grant some kind of unique animal. Or maybe there's special assistant that it needs to be done. So a helper monkey that's trained to turn on lights or do something for the owner because they're wheelchair bound, things like that. So service animals in training, this has come up a bit. An animal that's being trained as a service animal and a trainer of a service animal are entitled to accommodation. So if you have an individual who lives in your community, they are not disabled, but they are training service animals for a disabled individual, they are also entitled to the same accommodations that a disabled individual would be entitled to. An animal that's being trained as a service animal and a trainer, that's the same thing. So the trainer need not be disabled. So the big thing to remember, and we just had a case like this roughly 6 months ago, maybe 9 months ago, where the association was not allowing accommodations to the trainer because he wasn't disabled. And so that can be problematic, and the association can be subject to liability for that. All right, assistance animals is really a general term that includes both service animals and ESAs. So you'll hear a lot of people referring now as an assistant animal as kind of a catch-all. Important thing to remember about assistance animals or ESAs or support animals, they're not a pet. So any rules you have regarding a pet aren't going to apply. They are not a pet. They're one that works, provides assistance, or performs tasks. And it's for the benefit of a person with a disability, or provides emotional support that alleviates one or more identified symptoms or effects of a person's disability. That's what you see the most often is maybe the individual has anxiety, the doctor has prescribed a dog, and that dog is the ESA. That's the most common one that we run across almost all the time. For a support animal or an assistance animal, there's no training requirement for an assistance animal, no certification required. So if it simply is just a dog that a medical provider has said, or an animal that a medical provider says provides relief to this individual and helps them get about their day. They don't have to be specifically trained, and that's why you see so many of these online sites pop up where an owner will provide us some type of certificate saying they're an emotional support animal from an online. We don't particularly care about anything that is provided to us from an online because it's not from a medical provider. We're going to request additional information from a medical provider saying the owner is disabled or the individual is disabled. What is the accommodation that they're requesting? Specifically, in this case, it's going to be the emotional support animal. And what's the nexus between the disability and that ESA? And so if we get a letter from the doctor saying, or from a medical professional saying that, yes, the individual is under my care and has a anxiety issue, and it is my recommendation that this individual be allowed to have an emotional support animal to help deal with that anxiety. Once we get that information, there's not a whole lot the association can do. At that stage, we need to grant the accommodation, and the owner is going to get to have that ESA. So emotional support, which alleviates identified symptoms or effects of disability, that's what the ESAs do. That's why they can be so many different types of animals. It doesn't have to just be a dog because they're not trained for any specific matter. We can't do any limitations on breed and sizes to disallow any type of assistance animal. So again, if we have a 50-pound limit or specific breeds, those rules are not going to apply to a support animal or a service dog. A specific assistance animal may be disallowed if it poses a direct threat to the safety of others and would cause substantial physical damage to their property or others which cannot be reduced. So it's an outrageous thing, but if someone wanted an elephant as a assistance animal in a condominium, obviously that wouldn't work. We can't, it would cause too much damage. We couldn't get it into the thing. Something along those lines, that would be something that would allow us to deny it. However, we can't act on generalizations or general fears. So simply because it's a pit bull, that does not mean that it is going to be an aggressive dog. It must be on objective, individualized assessment. So ultimately, that dog is going to have to show aggressive tendencies before we could try and say you can't have this as an accommodation. Now, when we're evaluating requests for accommodations, some of the things that we want to make sure we're paying attention to and questions that we can ask is, does the person making the request have a disability? Does the person making the request have a disability-related need for an assistance animal? So again, that goes back to that nexus of what is the disability, what is the accommodation, and what's the nexus between the two. There's limitations on what can and should be asked of the requesting individual. So first, does the person have an obvious or apparent disability? If so, you should not and may not ask about that disability. So again, if the person's in a wheelchair, we don't need a letter from a doctor saying that they are disabled and have mobility issues. Again, if the person has obvious apparent disability, sorry, it's the same slide. I don't know why that got in there twice. So some of the questions that are allowed, specifically with the service animal. Is this a service animal that is required because of a disability? So the first question we're going to ask is this a service animal? That second question, again, we're talking about a service animal here. What work or task has the animal been trained for? And again, with service animals, as opposed to ESAs, these individuals are typically very disabled, and they are well aware of their rights, and they are well aware of the need of what this dog provides them. And so they will have all this information for you. Typically, they will submit it ahead of time when it's an actual service animal, and there's not a huge issue. Service animals are fairly rare, and you don't run across them all that often, but when you do, they're usually pretty easy to deal with because the owners have all of their ducks in a row. Now, with a emotional support animal, again, we need to remember, don't need training. Most owners who are submitting these don't understand the difference between an ESA and a service animal. It's just a hard distinction for them. They all kind of think of them as service animals, even though they're support animals and they have different rules that apply to them. So you got to be careful what you ask for. So oftentimes it'll be when they say it's a service animal, we go through those first two questions, and then it comes back that it's, oh, actually it's a support animal, it's not a service animal. So once we get to the support animal, or in a case where we don't hear, we have a person who doesn't have an apparent or obvious disability, we can request sufficient reliable information that will allow the association to verify that the resident meets the Fair Housing Act definition of being disabled, a description of the accommodation that the resident is requesting, and an explanation showing the relationship between the resident's disability and the need for the accommodation that is being requested. So again, if someone says, I need to have an emotional support dog, we need to have reliable information showing that they are disabled. Then we need to get the accommodation request asking what it is they're accommodating, in this case, some animal that would be otherwise prohibited. And then an explanation showing why their disability needs this animal in order to function properly. So requests for extraneous information regarding a requested accommodation have been found to constitute a denial of accommodation. So if you are asking outrageous questions or multiple questions, that can be seen as a denial and be discrimination just by doing that. So again, we would recommend sticking to just those three questions that we have outlined and not asking additional questions beyond that. A request for reasonable documentation of a disability and the disability-related need for an assistance animal. What is reliable documentation? So there's not a great deal of agreement. One thing that we certainly there is agreement on is that simply having an online letter is not reliable documentation. Typically what we're looking for is something from either a doctor or a PA, someone who they are actively seeing who has diagnosed them with some type of disability. So as long as we get a letter saying that this individual is disabled, we will be able, that's good enough. There are some things that say that simply an owner telling you that they're disabled is enough. I think that is a stretch unless you can actively see it. But there have been some cases that have gone that way. So it's tough, which is again why you need to get the attorney involved. So at least if the board is making a decision that this isn't reliable, that they're doing so on counsel's advice, and then that helps to protect both the association and the board. So things that are certainly reliable documentation. A determination from a government agency. So if someone has a handicapped placard for their car, that is probably good enough to say that they are disabled. Any kind of documented receipts of disability benefits, whether that's from the military or the government, that would work. Obviously, a note from a healthcare professional. Again, that note should explain that the accommodation or the animal provides support for whatever the issues are that deal with the symptoms. So again, if your disability is allergies, a dog probably is not a reasonable accommodation to that. There's no nexus between having allergies and also wanting a dog. Another thing when you're dealing with animals, you can't charge any fees or licensing charge or deposit for these because, again, they're not pets. So you can't charge them if they have an emotional support animal or a service animal. It's one of the times that you see people trying to abuse these laws is they want to get around these fees. They don't want to pay it. And so that's why they try and get them qualified as ESAs. So if it is an ESA or a service animal, again, we can't charge any of these fees. Another thing that has been popping up, especially in kind of high-rise communities, if they are requiring that the dog's stool be tested, there's often a charge for that. If you're one of those communities that does test dog poop to see where it came from, you can't put that charge back on the individual with the emotional support animal. That's something that the association would have to eat that fee. You also can't pass on any cost of attorney advice or fees. Even though we have the provisions in Kiowa that typically allow us to do that when we're dealing with something about reasonable accommodations or discrimination, things along those lines, those are not something that we can pass the attorney's fees along for. So when we're evaluating the request, we need to provide a reasonable opportunity for the requesting owner to provide adequate documentation. So if the request comes in, we need to let them know this is the information that we need and get it to us, and then we have to give them adequate time to provide that information to us. How much assistance guidance must be offered to the applicant to share what would be accepted? There's nothing that is black and white. I mean, again, going back to the kind of one of our earlier slides regarding CCRD, they want to see an interactive process. So if we need more information, they want us to quickly inform the owner that we need this additional information. Here's what we're looking for. We need reliable documentation that there is a disability. We need to know what the nexus is between your disability and the animal that you're requesting. So we want to have that dialogue. The more dialogue that we can show in terms of that, the more likely that if a CCRD complaint does get filed, that we can show we are being reasonable and we've done everything that we thought we should. So when you're evaluating things that we need to determine, does the individual have a disability? Is the requested accommodation necessary to afford equal opportunity to use or enjoy the premises? And was the requested accommodation reasonable? Those are the things that every board needs to be able to decide, again, presumably with the help of the attorney. I mean, typically they're going to be relying on what the attorney is telling them. And again, I would make sure you get this to the association's attorney as quickly as possible anytime you have a reasonable accommodation request, and certainly anytime you receive a CCRD complaint. Must allow reasonable modifications to property, either individuals or common property, to allow full use and enjoyment of the premises. So if there is a need for a disabled person to get to a second floor and we don't have the ability for that to happen, we must allow those modifications to allow them to get up there. So whether that is one of those chairs that rides up the side, maybe it's just as simple as hand railings, but things like that are going to have to, those modifications are going to have to be granted. It's deemed reasonable if it does not result in an undue financial and administrative burden like we talked about, or fundamentally alter the nature of the housing in question. So again, when we're evaluating it, we need to determine whether there is the disability, the modification is necessary, and the accommodation is reasonable. Those are obviously, we want to put those in there a couple of times so that those are the questions that need to be answered for any and all accommodations. We need to make sure, we want that hammered into your heads that if a accommodation request comes in, these are the things that we need to know for the board to be able to answer the question. And again, make sure you get it to the attorney. So I went through that as quickly as I could so that I could hopefully get to some of your questions since I was anticipating there being a few. First question, where is the nexus between a person claiming to be hearing impaired and claiming that their dog has been trained to alert them when alarms ring or when someone comes to their door or their phone rings? Their dog has been trained to alert them. Well, so I mean, I guess I don't know exactly what you mean by alert. So oftentimes, if it's a hearing impaired person, that dog has been trained to nudge the individual or run circles in front of them or do something along those lines to indicate to the owner that this is a noise is happening from somewhere. So typically they're trained to provide that assistance of here, if the doorbell rings, this is what you do. Maybe the doorbell rings and it's a nudge on the leg. Maybe the phone rings and it's circles in front of them. Things along those lines. So that would be kind of where the nexus would be between those two. Next question, can the community rules require that all children or minors have to be supervised by an adult in a hot tub or pool area? So safety is something that we can try and create rules for. However, the rules to say they have to be supervised is probably going to be discriminatory. Now, to say that individuals who cannot swim on their own have to have someone who is capable of swimming with them, that is something that's the way that we could write a rule that would allow for that. It's because you can have a 7-year-old that is a very proficient swimmer and should be able to use the pool, where you could have a 14-year-old who this is their first time in the pool at all, or an 18-year-old or a 20-year-old, whatever age you want to put, that this is their first time in a pool ever, and they might not know how to swim at all. So ultimately, what we want the requirements for pools to be around is your actual ability to use the pool. The rules in terms of using a hot tub or pool area in terms of swimming should be based on ability. Now, it's different of if you want to have rules that say there's no running, there's no whatever kind of, if we're dealing with the behavior side and you want to then issue fines because someone is behaving poorly, whether they're 21 or 12, we can create rules like that. But having the adult supervision is tough unless we're doing it at a very, very young age. Could you speak to the new 2016 quid pro quo hostile environment harassment rule? When is intervention in neighbor-to-neighbor disputes? So there's a case out of California that talks about neighbor-to-neighbor disputes and whether or not the association needs to step in and what is hostile environment. I mean, ultimately, associations can only enforce in a neighbor-to-neighbor dispute what is in their rules and in their guidelines, in their declaration. So typically what we would suggest is if there is a neighbor-to-neighbor dispute, maybe it's a noise violation, maybe it's something else, that the association send a warning letter to the individual so that the association can say, look, we got the complaint, we sent the warning letter, there's not much more we can do. We would also then, if it's a nuisance or depending on what it is, we would ask that complaining owner to provide us some additional information as to what exactly is going on. Maybe it's police reports, maybe it's recordings of the noise that is going on. So we want to make sure that the association has done something so that we can cover ourselves because the complaint came in. But the association typically in those situations is somewhat limited as to how far they can enforce. Again, without a specific instance as to what we're talking about neighbor to neighbor, it's hard to go into fact patterns, but oftentimes it's going to be some type of noise dispute, or maybe it's stacked units and the person upstairs is stomping. There used to be a bigger issue in terms of perhaps the individual next door had put up a sign that was racially motivated or something along those lines. In the past, we would have had to advise the association that we need to send letters saying that this isn't allowed. You can't be having signs like this. Now, unfortunately, associations can't deal with content of signs. There's nothing for the association to do in that type of scenario. All right, let's see. We've got some more questions coming in here. So again, there's a follow-up to the first question. The person claims hearing impaired dog trained bark to alert them. Again, I don't know. Perhaps whatever the hearing impairment is, the owner can hear the bark. I mean, without having the actual information, it's hard for me to tell you exactly. But if they have medical documentation showing that they need this dog, and the dog, and then we have documentation that the dog is trained to alert them, I don't think that there's a whole lot that you can do about that. I have no, it would be specific as to why they can hear this the dog bark, and maybe they're not completely hearing compromised. Maybe they have some portion of hearing that they can hear, and that's what the dog is trained to do. And the pitch of the dog's bark is something that can alert them. But again, it's kind of fact specific, so it's hard to give you an exact answer. If adult swim is discriminatory, does it follow that lap swim is discriminatory to older residents that don't wish to swim laps? No, I don't know why it would be. Lap swim is saying that, so ultimately you'd have an open swim and you'd have a lap swim. And so open swim, anyone can do whatever they want in the pool. They can just sit there if that's what they wish to do. They can jump around, they can sit there quietly, they can do whatever they want. Lap swim would require people just to swim laps. So I don't know why it would be discriminatory to older residents that don't wish to swim laps. Ultimately, what I think you're saying is the older people want to be able to sit in the pool without kids in there at all. And that's where you get into the discriminatory side of, you're now carving out a time where people who want to be calm get to do it without children. And so you are saying children don't have the ability to be calm. So I don't think that there's any discrimination in terms of a difference between adult swim and lap swim that older individuals would be able to claim discrimination. Should there be a policy regarding hostile environment harassment then? So there's something to enforce. I would not try and create something along hostile environment. I don't think you would want, the association isn't in the business of trying to solve neighbor-to-neighbor disputes. The association is there to increase property values, make sure there's a uniform look to the community. I would not advise trying to get into a hostile environment harassment policy personally. I think you're creating more effort and more concerns for the association, because now the board is having to determine whether or not this is hostile environment pursuant to the policy, and then trying to enforce that. I would not advise that. Do some of these rules related to children in a pool, for example, if the community is designated as senior or over 55 community? So again, HOPA communities, or those over 55 communities, they have different rules, and they're not subject to these kind of age discrimination claims. So it is typically okay for them to have pool rules that would, or any rule that might discriminate against people of a younger age. Specifically, the biggest rule of all is saying that you must be over 55 to live here. That in and of itself is age discrimination, but that's why there's a carve out saying that you can do that. Can HOA have adult-only events if alcohol is going to be served? Can they word it that only residents that are old enough to drink are allowed to attend? I mean, there's a whole slew of issues with having alcohol-related events that the HOA is sponsoring. Obviously, you would not want to be serving anyone under the age of 21. Could you specifically not allow or only allow people of age to drink? To be honest with you, I don't know off the top of my head if that would be something you could do. It's probably something we'd have to research. I mean, there's a bunch of insurance things that you'd have to look at. I mean, from a safety standpoint, it's possible we could argue that we don't want people under age of 21. But again, that's the real issue, is you can't serve them. So having them there shouldn't be an issue. If you just have adults-only events, it's possible it could be discrimination. It'd be something that I have to look at more. Can anyone else not hear me? I got a comment saying I can't hear you. If that is, can someone type in their response and see if they can hear me? Okay, perfect. Thank you. So what if the lap swim is unsupervised? Any exposure to HOA by allowing children without supervision? So just like any, I mean, a lot of the pools have no lifeguard ever on duty. Same with, I mean, so lap swim, presumably, what we would be saying, lap swim is for anyone to be swimming laps. So if they are capable of swimming it, then they should be able to do it. Without requiring adult supervision should not be one of them. Shouldn't be an issue in terms of lap swim. What if the lap swim is, so presumably you're saying, I'm guessing that the lifeguards take a break during this 15-minute time, or however long the lap swim is. What happens if a adult has a heart attack in there, or something along those lines? So I don't think there's any additional exposure. Ultimately, lap swim is meant for anyone who has the ability to swim laps, and if they suffer some type of medical emergency while that's happening, I don't think that you're dealing with any additional liability. So we are at 1 o'clock. That is the last question that I am showing. If you guys have additional questions, please feel free to reach out to me directly. I appreciate you guys sitting in and listening to this. Hopefully you got some benefit out of there. If nothing else, make sure anytime you are dealing with disability or CCRD that you are getting those over to your attorney as quickly as possible. If you would like a copy of the slides, please reach out to Sean directly at 303-991-2076. Thank you all.